Hey, it's on!
Ooh.
It's on! Woohoo!
Okay, here we go. First edition of what I'm going to call Terry TV, and I've got my good friend Mark Kosieradzki. We've been friends for several years, met through the nursing home litigation group through the American Association of Justice. And in my opinion, Mark there is one of the best lawyers in America, lives in Minneapolis, Minnesota for some reason. I can't figure that part out. We're recording this in December now. What's the weather like up there, Mark?
Oh, it's beautiful. We got big, flaky snow coming down. It's a balmy 25 degrees. It's beautiful. I don't know why you wouldn't want to come up here.
And it's
walk on the ice.
It's only going to get colder. So,
Pretty.
Mark, you're a regular speaker around the country on deposition practice and on cost reports. By the way, we need to have another discussion sometime on cost reports.
I'm all in.
But I first saw you, I forget where it was, but I wondered, who is this guy who has the unfortunate situation of having all this hair on his head, comes out to talk at a nursing home seminar and whips out a harmonica and starts ripping some tunes on a harmonica. And I'm like, I like this guy. He's not a boring speaker. So I appreciate you coming on for our inaugural episode of Terry TV. Tell me, what kind of work do you do?
Well, my practice, I've been practicing for 39 years, so I've done everything. And I've done everything from dog bites to major civil rights actions, medical malpractice, construction, products liability. I've done all of them. It's just, that's, if you're old, you end up doing everything.
Right.
At this time, I'd say probably 75% of my practice is nursing home or elder abuse. And then, 25, maybe a third of my practice is I join trial teams around the country to help them with the litigation strategy and their 30B6 depositions.
Okay. So we both do nursing home cases. That's kind of how we met. What drew you to elder abuse or nursing home cases?
It's kind of interesting. For the first 2 decades of my practice, every time there was an elder case, most people would say, there's no, we can't afford to handle it. The life expectancy of a 90-year-old is 3 years. The juries won't recognize the damages. I kind of bought into that. And then 20 years ago, actually a little more, 22 years ago, I decided to start my own firm. So I would take everything that came in the door because I was starting over. And I had a nursing home case, and it just seemed wrong. This poor person had been abused and left to rot. And it was really bothering me. So I said, I'm going to take it. And what I started thinking is, the people who worked in the nursing home they weren't evil people. What was happening is they were being asked to do impossible tasks because the companies were, cutting money, cutting staff, cutting supplies. And I realized what the real issue was is people were being killed for money. And so I changed my paradigm of how I evaluated the case and determined that it's not about, X dollars per day for 3 years, but rather that there are really human damages, that lives have changed and people are making decisions and betraying the trust of people. And all of a sudden I realized these are important cases. And they were economically feasible to handle because juries recognized the importance of the decision making by these companies that resulted in killing their loved ones.
Yeah.
So I ended up doing it.
Well, I'm the same way, and I have run across just some egregious fact patterns in the cases that I've handled. I'm sure you have too. And it just boggles my mind when I tell people about the kind of cases that I handle. They're like the same way. Well, what are the damages there for somebody who's got maybe 6 months or so to live? But when you tell them all the terrible things that some of these elderly folks have to go through, it's just, they're just outraged, and good for them. But
well, like when I would come home and tell my kids about it, they thought, oh, Dad's just making that stuff up. Right. And then they spent a summer working for me, and they said they couldn't believe it. They said, this is really true. People are really doing this. Yeah. And they really said, thank you, Dad, for doing it, because we do make a difference. And it's interesting that if you hold them, they're not going to shut down the company. They make too much money. But what you can do is if you hold them accountable in a way that it hurts, they start changing the way they do business.
Right. I agree. I used to, 10 years or so ago, I had a rash of what we call bed rail asphyxiation cases where, the mattress doesn't fit. They put the small person on there, they wiggle through, and they end up getting hung on a bed rail. I don't see a lot of those today because the companies, for the most part, have really tried to eliminate those, and they've improved the care in that respect. They're still out there periodically, but I don't see near as many of them as I used to.
Well, it costs them too much to get bad care.
Right. So let's transition over to depositions. That's what we're going to talk about today. So for the non-lawyers who may watch this, depositions, kind of in general, that's where one lawyer for a party is taking or asking questions of another party to a lawsuit, or a witness, a family member, a doctor, something like that. It's a formal or semi-formal setting with a court reporter transcribing what's said. And before the deposition, so if I'm sending your client, if I want to depose your client, I just send you a notice of deposition that says I want to depose John Doe on such and such a date. I don't have to give an outline to questions or anything like that. And we take a ton of these. These depositions are one of the most common things that we do as lawyers. But there's another kind of deposition that people aren't as familiar with, and that's the corporate representative deposition. Now, you've written this book, the 30B6, Deposing Corporations, Organizations, and the Government. Mine is not autographed, by the way. We need
Next time I'm in Missouri, I would be happy to do so.
Sounds good. So this book's about the deposition of corporate representatives. So tell us, what is a corporate representative?
Well, it's actually more than a corporation. Anytime you have an institution, it could be a partnership, an LLC, a corporation, the government, some organized body of human beings together that are acting, with like a common purpose. And that organization has information that you want to get. The traditional way of getting that information is to ask someone some questions, and they say, I don't know, ask someone else. And then ask someone else, and you keep going and going and going. It's literally a case of hide the ball.
Right.
And tragically, and I really do mean tragically, the legal industry has gone into the concept of cases should be won by how much information you can hide versus whether or not the case should be won on the truth, the merits. So this rule comes up saying this cat and mouse game isn't working. So I don't know, 35 years ago or so, the Federal Rules Committee said, let's do something different than saying, I want to depose Mr. Terry, or I want to depose the design engineer, or the administrator of the hospital. Why don't we cut through the nonsense? Why don't we say, what is it you want to know? Tell them what you want to know, and they need to tell you. So a 30B6 deposition is named after the rule, Federal Rule of Civil Procedure 30B6. And what it says is, if you've got an institution, not a human being, but an institution, you can tell them, here are the things I want to know about, A, B, C, D, whatever. And you got to tell them. You got to tell them what the rule says, reasonable particularity. You got to say, this is the stuff that I need to know so I can make decisions about this lawsuit, and a jury can make decisions. And then their responsibility is to pick a person or multiple people, it doesn't matter, to provide all of the information known to that organization. So you're going to say, doesn't matter, General Motors, United Healthcare, Walmart, Costco, the Joe Blow law firm, or the we take care of you healthcare clinic. It doesn't matter. Whoever they are, if they're an organization, you serve or give the organization this notice, this piece of paper that says, we need to know this information. Tell us, you pick anybody you want and tell us what the organization knows. So that's 30B6.
So how detailed do those notices have to be? Because we lawyers like to say, we like to talk in broad topics up to and including, but not limited to, that kind of language. Does that work in a 30B6 depo notice?
No. The whole concept is the organization has a duty to prepare. And they can only prepare if they know what they're supposed to prepare for.
Right.
So you say including but not limited to. Let's say, like, David, I'm going to ask you everything, including but not limited to what you did last night. Well, how do you prepare for that? You can prepare for last night, but you have no idea what the other questions are going to be. So the rule says they have to ask within reasonable particularity, that's the rule. There are some jurisdictions, areas of the country where the courts want more, where they use a term called painstaking specificity. So you got to lay it out in detail what we're looking for. I think as a practical matter is, I like to call it the "are you kidding" standard, that if you go in front of a judge and they say, I don't know what he's asking, the judge is going to say, really? Are you kidding? Anybody would know this. So what you have to do is give enough of a description so the organization can say, hey, we know what we got to get ready for, and we're going to do it. So that's the standard.
So you don't have to give them your questions. You just have to give them a detailed description of your topic.
Yeah, well, you have to say, this is the area that we're going to be talking about. And if you got a very specific thing that you have to know, then lay it out. But the whole idea is it's got to be broad enough so you might learn something that's associated with it that any reasonable person would know. A perfect example is I had a 30B6 deposition of an organization about security cameras. And I said, I want you to come in here and tell us about your security camera and tell us about all the videos you have. Well, they play the game and say, we don't have any videos. I said, well, come on, we got cameras up there. He says, those are digital images. They're not video. It's a game. It's nonsense. That's the kind of thing a court's going to say, are you kidding? Really? But then, you say, I don't really care about locks on doors on the other warehouse. I want to know where the camera is pointing. And is it pointing in the area that deals with the problem I have? So I start with a real broad topic. We're going to talk about the security surveillance system. He said, I'd like to know what kind of system you have, how does it work, where the cameras are there any cameras pointed to this area, and how are those videos preserved? I really don't think you have to ask all of those details, but if you want to make sure you've got it, that's how you do it.
And they have a responsibility to produce the person most knowledgeable about each topic, right?
That's not true. That goes back in time before 30B6. The person with most knowledge might only know 10% of the information. They have a responsibility to gather all information known or reasonably available to the organization and teach someone, train them, and make sure that that person could relate all the knowledge known to the organization to the lawyer who's asking the questions. So that's a misnomer that lawyers use all the time, because before 30b-6, they would say, I don't know who the person is, so give me the person with most knowledge who comes in with 10% of the knowledge. And 90% is still gone.
So the corporation or the entity has a duty then to prepare somebody to provide all the information that's available to them.
Absolutely. That is the core of the rule. They have a duty. They've got to look. They've got to look at it. And they got to talk. Who are the people who have information that is responsive to the questions that you put in your notice? What are the documents that have information? And what is the electronically stored information that has a responsive information? So they've got a duty to look at all of those things so they can come back and they can tell you, yeah, these are the things we've looked at. These are the things that have the information. And here's the answers to your questions. But for them to look, they have to have some idea what you're going to ask them.
All right, so when do you take these? There's different schools of thought on when you take certain depositions. Some people say you take them at the beginning, some in the middle, some at the end. When does Mark Kosieradzki strategize on taking a corporate rep deposition?
At the right time.
There's a good lawyer answer.
Well, I mean, depends what the 30b-6 deposition is going to be. If I'm taking a 30b-6 deposition that's going to say, I want to know how your computer system is set up and how information can be accessed so I can ask for information without overburdening everyone, then I take that at the beginning. If I want to know what is the argument that the defendant, in my case, who's I'm a plaintiff lawyer usually, is going to make about what they claim happened, I'm going to do it after they've taken the testimony, or I've taken the testimony of the non-party witnesses. Because otherwise they can say, we don't have access to the information known to these people who aren't with us anymore. If it's a body of information that they uniquely have, then I ask for it at the beginning. So it depends on what you're looking for. And oftentimes I'll take multiple 30b-6 depositions in a case. So, but they have to be on different topics.
So let me talk about a nursing home case. Do you take 30b-6s on case facts, or do you rely upon the fact witnesses for that, or do you do both?
I do both. I usually will take a 30b-6 at the beginning to identify various records and electronically stored information, so I can know what to ask for, how to ask for, and frankly, preempt a lot of the objections that the industry throws at us that are just boilerplate. They don't mean anything. So I can preempt the nonsense. I try to make a record of that. You know, you'd say, well, why do you need to do that? They've got a duty to answer it accurately. It's true, but you know, this is America in 2018. It's win at all costs. So what we do is we preempt the nonsense in advance. If there's a specific witness that I know has information, and it's important to find out what that particular witness is going to say, then I take that witness's deposition. If I want to find out globally, something like using your bed rail example, you know, why did you use bed rails? Are there any policies on them? What is the process that the organization went through to make the decision to use them? Who installed them? And then what you claimed happened? I can do that all in one deposition. Particularly, because otherwise I got to be just like, you know, playing whack the mole, trying to find out who's got the answers to all of those questions.
So I started doing these corporate representative or 30B6 depositions probably after I heard you speak one time. So I've been doing them for 10 years or so. Tell us, why are these depositions so powerful?
Well, because if you ask the questions properly, then they have to give you information, and they can't change it later on.
Right.
And so there's this whole, it's called binding of fact. And there's litigation has historically been trial by ambush. And the courts have tried to eliminate that and say, let's take factual disputes and everything that's, agreed upon, let's figure out what that is. And the trial should be about where there's a dispute about the facts. But in this win at all costs world we're in, they say hide the facts and then ambush at trial. So this is a way to lock them down, get information, and frankly, eliminate the middleman, which is the lawyer on the other side, from filtering those facts. So you can get to the truth faster and more efficiently.
So there's something that, the folks that don't do this every day probably aren't aware of, but at the end of a deposition, the court reporter sends the witness a little booklet, and it's got something called an errata sheet, something where they make some changes or put some different information in there. Explain what happens in a situation where you've taken a 30B6 deposition and they try to change their testimony using that errata sheet.
When we start, you got to know what the rule is. They have to provide the errata sheet within 30 days of the time the deposition is made available. If they make a change, they have to say why they made the change. Now, there's 3 schools, it basically varies by jurisdiction. There's one jurisdiction that says you can make any change you want. A couple of jurisdictions say you can correct an error by the court reporter. The vast majority says you can't change the substance of what you're saying. There's a great case out of Louisiana that says a deposition is not a take-home exam, which I think is a really good, analogy.
Description, yeah.
And if, in a timely fashion, the substance of the deposition is changed, then most jurisdictions will allow the lawyer to reopen the deposition on the areas that were changed to explore why they were changed. And most jurisdictions will say, if a lawyer told you to change it, then what did the lawyer say? Because remember, it's the witness that has the facts, not the lawyer. And so lawyers have to be really careful in how they guide their clients, because they can't make up the facts. I mean, that's unethical.
Do you ever run into questions or problems where if you're trying to find out why their testimony was changed, or if during a break they come back and they change their testimony, you say, hey, did you talk with your lawyer? Did your lawyer give you information? Do you ever run into these deposition objections where, hey, that's attorney-client privilege, you can't talk about that, just take his deposition? 2 schools of thought.
I actually have a new book coming out of this in January that deals with the majority of jurisdictions say that you're not supposed to talk to your clients on breaks.
Right.
And we tried a case about 2 months ago where the judge at the conclusion, before every recess, would admonish any witness that was on the stand and warn them and said, can't talk to your lawyers during this break. That's not every jurisdiction, but that's the majority. In those jurisdictions, you can say, if they change their answer, what is the basis of changing that answer? And what did the lawyer tell you? And that's considered a waiver of attorney-client privilege. There's another line of cases that comes out of Nevada that says no, lawyers can talk to their clients to help clarify things. But where it's a gray area is if they go from yes to no or black to white based on what the lawyer said, then the question becomes in those jurisdictions, can you say, what did the lawyer tell you? And that changes from jurisdiction to jurisdiction. And I use the term jurisdiction because in the federal courts, it's broader than just that state. The technique I like to do, and it's a nice way to do it, is after every break, I said, you're welcome back, are you ready to go? Have you talked to your lawyers over the break? Yes, are you there? And if so, do you want to change anything? And 99 times out of 100, they'll say no, which makes it a lot harder to make an erratic change later on.
Right.
If they do want to change something, depending on what jurisdiction you're in, you can say, okay, why are you changing it? What information do you have now that you didn't have?
Right.
And where did you get that information? But even if you're in a jurisdiction that doesn't allow you to ask about what the lawyer said, once you have it on the record, I talked to my lawyer and now I'm changing my story, the jury bias issue comes in and says, yeah, damn lawyer was manipulating the truth.
That's exactly right. All right, just a couple more minutes here.
What did you want, my friend?
I've been in some depositions, and some of these defense lawyers, I'm convinced that they go to deposition school and they get paid by the hour in depositions, or by the word, and they try to talk and really focus on how can I manipulate this deposition to get my client to testify how I want them to. And so they'll have these speaking objections that choreograph how they are to answer, how their witnesses to answer questions. How do you shut that down in a deposition?
Well, that's what my new book is about. It's coming out in January, and it's going to be called...
Maybe I'll get an autographed copy of that one.
What's that?
Maybe I'll get an autographed copy of that one.
They're going to be launching it at the AAJ convention in Miami. There'll be a book signing. So come there, and I'll personalize it for you. But here's where I'm at. A lot of lawyers want to, say, I'm going to shut it down, and they want to get in these fights. And say, you know what? It didn't accomplish anything. Number one, it's unethical to coach a witness.
Right.
It's unethical to obstruct. The jurisprudence is universal. 50 states, all federal and state jurisdictions, that witness coaching is prohibited. Speaking objections are prohibited, but they do them anyway. And why? And the reason they do it is because nobody ever does anything about it. So I think the technique that I advocate as one of professionalism is if every time there's a speaking objection, you make a comment that says, please don't make suggestive comments in front of the witness. Nothing else. Don't get in a fight. Don't lecture them on the law. They know what the law is. They should. And the more they object, the worse it is for them. Because then, if you've got someone who's being legitimately abusive, or legitimately, or not legitimately, who is being abusive, or is witness coaching, all you do is just, if you get in a fight with them, it's not going to accomplish anything. You just say, please don't make suggestive comments. They keep doing it, go through the deposition, do the best you can, get what you can, and then when it comes in, use an old-fashioned technique. A highlighter. Every time they're talking, highlight it, and go to the court and say, yeah, I'm sorry we're here, but the rules are very clear that you do what you do at trial. And this is, look at the transcript. 32% of the spoken word on the transcript is a lawyer talking. Pretty embarrassing for them because they know damn well they can't do that.
Right.
If they instruct not to answer, the only reason to instruct someone not to answer is for privilege or for a court-imposed limitation. They say, I don't like the question. I'm instructing you not to answer. It's beyond the scope of the 30B6 deposition. I'm instructing you not to answer. Prohibited is a case I cite in the book. This is for all the ambiguity in the law. There is no ambiguity on the instruction not to answer. Because what they don't seem to get through their head is, lawyers don't get to rule on their own objections. The court is the only one who can rule on their own objections. So they can, they make the objection, but the court rules on it. So, but if they start instructing not to answer, I'm not going to shut it down there. I just keep asking every question. And the more they instruct not to answer, the worse it gets for them. So, give them enough rope and they'll hang themselves. It's kind of an ugly metaphor, but it's true. I'm a big advocate of professionalism. I'm a big advocate of firmly insisting that the questions be answered. But I don't think you accomplish anything by getting in a fight with a lawyer in front of their client and embarrassing them in front of their client because they're going to have to try to protect themselves, emotionally and professionally, so they don't look like don't know what they're talking about.
I agree. All right. So I take these depositions in large part using, did I mention this book? Using this book as a reference. So, but I know lawyers who don't take 30B6 depositions. They don't pursue the corporate representative. So in the last question that I have for you, for the lawyer who's watching this, who doesn't take these depositions, convince them that they should.
Well, if you want to cut the cost of your case, cut the nonsense, take the middleman out and get to the heart right away, it's a good thing to do. If you want to spend a lot of money and take lots of depositions and not get anything, then don't use them.
All right, Mark. Hey, man, thanks so much. I really do appreciate it. And I hope the cold gets better and try to stay warm up there.
Should I finish it the usual way?
Sure, absolutely. Did you bring it?
Now you got it.
Exactly it. Thanks a
for
lot,
having
Mark.
me, David.
Thanks a lot, man. We'll see you later.
Bye.
Aw, man, it's over.
No!
Wow, that was really good.